Thanks everybody for joining us today. Just our quick standard disclaimer, this presentation is for educational purposes only. It's not legal advice and it does not create an attorney-client relationship out of thin air. This is also a new issue for us. We're providing an overview on this. If you're already one of our clients and you have questions on the materials we're covering today, please send us a question through our portal. If you're listening and you're not yet a client, we'll have some information at the end how you can join up with us if you've got some questions on specific legal issues. We'll try to go through this, everybody, within our allotted time so you can keep your day moving. So we're talking about the Minnesota Paid Family and Medical Leave law. It's a new law and there's quite a bit to unpack, so we'll sort of jump right into it. The law was signed in 2023, so a couple of years ago, and a time frame was included with it for a rollout. Now, we and most people have referred to it as Paid Family and Medical Leave in Minnesota, or PFML. However, if you're looking at any state materials, and they have some good information, which we'll talk about in a little bit, but the state of Minnesota refers to this as paid leave. So as we're speaking today, when I'm using, or Andrew is using the term paid leave, this is what we're talking about, the Paid Family and Medical Leave law, the new law. Don't confuse it with the Minnesota State Earned Sick and Safe Time, or the ESST law, or don't confuse it with some cities in Minnesota that have paid sick time. This is a totally separate law that has new requirements for it that employers need to follow. Also, don't confuse it with Minnesota's Pregnancy and Parenting Leave law. So this is a new law, paid leave, that is layered on top of several other existing laws in Minnesota, and it's important to kind of keep everything straight when you're looking at a situation with an employee. So that's why we wanted to present specifically on paid leave today, to give you an idea of what's going on. So what is it? Really, it's a state-run program that provides employees with paid time off for medical leave, and also time to care for someone leave. It's basically a new state entitlement program, and it provides wage replacement. Point number one, it provides wage replacement to workers that are eligible to use paid leave. And then point number two, it also provides job protection. So it's similar to the federal FMLA, and that an employee who's eligible for paid leave in Minnesota gets job protection for that leave if they're using it for a permitted purpose. We'll get into more details on this, but I just kind of wanted to lay out that background. The two important things to consider it's a wage replacement law, and it's a job protection law. Now the paid leave can be used starting as of January 1, 2026. So that's, short of 2.5 months out. It's coming up quickly. There's some deadlines that are approaching, so that we're going to talk about that today as we go forward. Important question from employers: who is covered by this law? Well, most employers are going to be subject to this law, even small businesses. This law was written basically to get as many employers under it as possible. There's a tie-in with the paid leave law to the Minnesota unemployment insurance system, and we'll be discussing that in a little bit. The employers who are not covered by this law are federal government workers, and then some seasonal workers in certain hospitality industries are not covered by it. But covered employers, if you're a covered employer, as noted here, you do not have the ability to approve an employee taking paid leave. That decision is not in your hands. That decision is in the hands of the state. You can't tell an employee if they're eligible. They don't get the paid leave benefit. That's, again, handled by the state. Also, an employer cannot deny an eligible employee's application for paid leave. So if one of your employees, and you're a covered employer, one of your employees applies, you don't have the power to say, yeah, we're not going to approve that. That's not how this works. The state makes the eligibility determination. If an employee is eligible, they apply for state leave, they're for paid leave, excuse me, with the state, and the state approves it, they get the benefits. The employer is not eligible to participate in the application process by denying or approving someone's paid leave application. An employer must also return an eligible employee to their position once they are done with their paid leave. So again, that is the state requirement of job protection under this law. However, the job protection element of the paid leave law doesn't kick in unless the employee has worked 90 days for you. What about paid leave coverage for employees? Again, this law was extremely broadly written to ensnare the maximum number of employers as well as a large number of employees. So most employees who work in Minnesota are eligible. We'll talk about some of the qualifiers on this, but that includes part-time, full-time, temporary, people with many jobs, a lot of specific seasonal workers, younger workers, undocumented workers. Those people are covered. However, to be eligible, an employee has to work in Minnesota for more than 50% of the year, or they have to live in Minnesota and perform work in Minnesota. They just can't do more than 50% of their work in another state. So you've got to look at that 50% of time performing work in Minnesota. In addition, an employee must have earned at least 5.3% of the state's average annual wage in the last 12 months, rounded down to the next $100. That's a fancy way of saying going into this program becoming effective for an employee to be eligible, the person must have earned approximately $3,700 to $3,900 prior to applying for paid leave. So who are some of the workers who are not covered by paid leave? So independent contractors, people who are self-employed, tribal nation members, federal employees, and certain seasonal hospitality workers, again, not covered. Some workers can, however, opt into the paid leave program if they choose, but again, there's such wide coverage that may not be an issue within your business. If you did have a question on that, you of course could ask us if you're one of our clients. The paid leave, as we've mentioned, is job protected if the employee has been at work for you for 90 or more days. And an eligible employee must be restored to their job after using paid leave if they've worked for you long enough, again, the 90 days, to have that job protection element in place. There's also a benefits continuation part of the paid leave law. So an employer under this state law has to continue things like health insurance while the eligible employee is on paid leave. For those of you with 50 or more employees, you're probably used to that requirement under FMLA. If somebody's eligible for FMLA, there are some similarities between the Minnesota paid leave law and FMLA. However, there's quite a few differences too. We'll talk about that, but continuing benefits eligibility is one of the requirements under the Minnesota paid leave law. So an employee wants to use paid leave. What are some of the reasons for use? Well, as we mentioned at the very top, it can be used for an employee's own serious health condition. And under this law, that means a physical or mental illness, injury, impairment, condition, or substance abuse disorder of the employee. And that can involve inpatient care, continuing treatment, or a period of incapacity. With the paid leave law, 7 or more days of the need for leave is what they look at. An employee who's experiencing a serious health condition could use paid leave, again, if they're eligible for things like evaluation of their health, treatment, inpatient care, substance abuse recovery, or if they're not able to perform their regular work or daily activities. So under that definition, under this law, that includes childbirth, conditions related to pregnancy or surgery. So those are the medical leave reasons that an employee could use paid leave. How about family leave? There's some broad categories under there. The first one is bonding leave. So that means an employee takes time to care for or bond with a new child that arrives in the family through birth, adoption, or foster placement. That's number one. Number two is the caring leave. That means to care for a family member with a serious health condition, and that person does not have to be located in Minnesota. Number three is military family leave, and that's used to support a family member called to active duty. And then number four is safety leave. Again, under the family leave portion, that's to respond to issues such as domestic violence, sexual assault, or stalking. What is the duration of paid leave that an employee can take? You've got an employee, they're eligible, they apply to the state approves it. What duration are they going to be gone from your business? So up to 12 weeks of paid leave can be used for an employee's own serious health condition. So we mentioned FMLA a little bit ago. That's a similar time frame that people keep in their minds. In addition, or separately, I should say, there can be up to 12 weeks of care leave that an employee can take within a year. So that's to look after someone. Again, the child bonding, the military family leave, and the safety leave related to domestic issues. And leave for an employee's own serious health condition or family care can be taken either in a block of time, 1 week, 2 week, up to 12 weeks, or it can be used intermittently. However, and this is important, the combined total for medical and care leave can't exceed 20 weeks in a 12-month period. So even though on the face of the statute, you could take 12 weeks standing alone for medical leave, you could take 12 weeks standing alone for care leave. If you're taking both types of leave, the total cannot exceed 20 weeks in a year. And the 12-month period, when you're measuring how much leave is used, starts from the date of first use under a state leave plan. And we'll talk about the different types of plans coming up shortly. All right, you've got an employee that wants to take paid leave for one of the reasons we've just discussed. What is the process that the employee follows to get their paid leave application up and running? So first off, an employee is required to provide their employer with notice of the need for family leave. If their need for leave is foreseeable, say they're going to have surgery in 2 months, the employee must provide notice to the employee at least 30 days in advance for foreseeable leave. For unforeseeable leave, the employee has to provide notice to the employer as soon as practicable. And how leave is provided, the employee needs to provide at least oral, telephone, or text message notice that's sufficient to make the employer aware that the employee needs paid leave and the anticipated timing of the leave, as well as the duration of the leave. And an employee also has to advise if they're going to be taking leave in a continuous block or if it's going to be intermittent. And with intermittent paid leave use, the employee must provide a schedule of needed paid leave off as soon as practicable. That's a fancy way of saying as soon as they can. And the employee under this Minnesota paid leave law must also try to schedule their intermittent paid leave to not unduly disrupt employer operations. So as an employer, just know that employees have an obligation to try to schedule their intermittent leave so it doesn't overly affect your business. The next step is the employee then contacts the state to apply. The state has this set up so it can be done online, or it can even be done by phone. If the need for leave is foreseeable, the employee has to apply within 30 days of the event. The employee also has to provide information to the state. It's not just a blanket rubber stamp by the state, even though this is a pretty broad-reaching law. The employee has some obligations. They have to tell the state about their background, their job details, their reason for taking leave. What type of leave is it? Is it medical? Is it family care leave? The expected length of leave, and importantly, the employer also has to provide the state with a certification from a medical professional, a service provider, or other supporting documentation about the employee's reason for leave. So again, the state just doesn't rubber stamp. The employee has some hoops to jump through to get their paid leave approved. And then the state makes the decision if the employee is eligible for paid leave and if they will receive paid leave benefits. Again, as the employer, you can't stop an employee from applying. You don't have any input on their application process. However, the state is going to make them jump through some hoops. What are some of the state timeframes when an application is received? They have 5 days to notify the employer when an employee has applied for paid leave. So if somebody applies, you will get notice within 5 days of that application. And then the state has 2 weeks to make a decision on whether an employee is eligible for paid leave or if they're going to ask for more information from the employee. So again, with this process, at least you will get notice if somebody has applied for paid leave. And in theory, they need to let you know as well, as we discussed earlier. Now, employer designation is also required for use of paid leave. If the state notifies you that somebody is eligible for paid leave, you as the employer, when you receive that information, you have to designate that leave as paid leave if it qualifies, and you've got to provide the designation notice to the employee. So a little more detail on the paid leave benefits. We gave sort of an overview earlier, but let's get into some of the details. So again, there's job protection. If an employee is approved for paid leave by the state, they have job protection if they've completed 90 days of employment. An employee can't be fired or have disciplinary action taken against them for using paid leave. They also must be restored to the same job or an equivalent job with the same paid benefits and work conditions. That's a pretty big ask, but it is a requirement of the law. The other piece of the law that is provided is wage replacement benefits. So this law is really a wage replacement law where they offer up to 90% of an employee's average weekly wage. Just for 2026, the numbers from the state is somebody could not make more than $1,423 a week. That's the very top end of the scale. The payments are made if wage replacement benefits are included. The payments are made directly by the state to the employee. It's similar to the Minnesota's unemployment insurance program. So the same organization, and we'll talk about this a little more, but the same organization that covers unemployment insurance in Minnesota also administers this paid leave program. It's the Department of Employment and Economic Development, DEED. We'll get more into that, but they make the determination and they make the payments. Also, as noted, you have that requirement as an employer to keep the benefits of the employee going during their paid leave time. Let's talk about a qualifying event for paid leave use. So what is it? A single event lasting at least 7 consecutive calendar days could be considered a qualifying event for paid leave, and it must relate to medical care, family care, military leave, or safety leave, as we've been discussing. But, and we touched on this a little bit before, the single event requirement of 7 days is not needed if the paid leave use will be intermittent. With a qualifying event for paid leave use, employees must provide certification regarding the need. A little more detail on that. If it's medical leave, the employee needs to provide to the state with their application something from a healthcare provider that talks about the serious health condition and the amount of time needed. If it's for care leave, they need to talk about what's going on. They need a certificate from the family member's healthcare provider that shows the employee's care is medically needed by the family member. So again, the state has built in some hoops for the employees to jump through. For bonding leave, the documentation is going to be, again, from a healthcare provider, an adoption agency, a foster agency, something that proves you've got a child in your home. And for military leave, the employee would need to provide a copy of the active duty orders of the affected family member or another military document. For safety leave, the documentation would include proof that could be a letter from a qualified professional, such as a domestic violence advocate, a counselor, an attorney, a police report, something along those lines. Importantly, with paid leave, there is no waiting time for benefits. There's not what's called an elimination period, for example, where the employee isn't covered by benefits. Some states with work comp benefits, there is a several-day waiting period. With paid leave, there is no waiting period for benefits. If somebody doesn't get benefits right away and they're later awarded benefits, they will be retroactive to the beginning of the qualified leave use. This is a huge question now that we're going to discuss that we've gotten from quite a few employers who have concerns on this law. How is this paid leave program funded in Minnesota? Well, it's being funded through basically a new payroll tax. The amount of that payroll tax is 0.88% of taxable wages paid by the employer for employers with 30 or more employees. So that's what's called a large employer, 0.88% of taxable wages. We'll talk about small employers shortly, but keep that number in mind. It's being framed by the state as similar to an insurance plan. The state is basically treating paid leave similarly to unemployment insurance, as previously noted. Both programs are administered by deed in Minnesota. But importantly, paid leave premiums can be split between the employer and the employee, similar to how a traditional health insurance plan would work. By law, the employer must cover at least half of the paid leave premiums, and then an employer could choose to pay more than 50% of the paid leave premiums to cover the employee portion, but it's not required to do so. But that's something to keep in mind with that 0.88% of taxable wages, the premium amount that's required for large employers, the employer has to pay at least half of that. Employers can begin deducting the employee portion of the paid leave premiums from employee pay on January 1, 2026. That is, again, if the employer is paying half of that required amount, the other half can be put on the employees through a payroll deduction. Most employers are not planning on covering their employee share of the paid leave premiums. I've heard this anecdotally. The employers are going to pay the amount that they are required to pay of that premium by law, but then they are going to move the remaining amount onto their employees. A lot of employers have been a little frustrated with this program, and so they are not going to pay any more than they need to, and they are going to shift the burden that they are legally allowed to shift onto employees, onto their workers through those payroll deductions. A possible exception to this could be if there are minimum wage employees. If an employee makes minimum wage and the employee portion of paid leave premium contributions would take the employee below minimum wage, then the employer would have to pay a higher premium amount for that employee. The amount deducted from an employee's pay to cover their portion of the paid leave premium cannot take them below minimum wage. Now my colleague Andrew is going to talk about small employers and how this works.
Thanks, Michael. All this, as I've been sitting back and just listening, it kind of struck me that all this is kind of really similar to unemployment and FMLA if you Frankenstein them together and mash them all up in the state of Minnesota, with some obvious exceptions. So for those of you just thinking anecdotally, those of you who have experience with FMLA, there's going to be some similarities for you. For those of you who have experience with the Minnesota unemployment process, there's going to be some similarities for you. Just a thought that popped in my head as I was listening to Michael talk. But anyways, on to what Michael really wants me to talk about is small employers. So small employers have slightly different rules than large employers. We're talking about a small employer defined here as 30 or fewer employees. The premium amount, if you look at it, is only 0.66% of the taxable wages as opposed to the 0.88 for the large employers. And that's, if you do the math, which I don't, thanks Michael for doing the math, that's 3/4 or 75% of the large employer rate. The way this one is broken down is the employer has to pay at least 0.22%, and the employee is on the hook for 0.44% of the payment. Deed has a wonderful calculator. For those of you like me who don't love math and aren't, spreadsheet wizards, you can use the Deed calculator on their paid leave site to estimate premiums, and they'll help you figure that all out so that you can at least get your head around it without having to sprain yourself because you haven't taken a math class since 1996 like me. Also, for small employers, we're going to talk a little bit about assistance grants. So the state has provided some small employer assistance grants from this that will be made available starting in January of next year. Dan, if you want to jump to the next slide. This small assistance or small employer assistance grants are to help employers cover the costs that they incur when an employee takes paid leave. Now, I'm probably saying, Andy, what kind of cost are we going to incur because we pay into this premium amount and then the state pays out the benefit to the employee? Well, we're not talking about the paid leave benefit. We're talking about helping small employers cover for that missing worker. So this, money can be used to help hire temps. You go to a staffing agency, a temporary staffing agency, you hire a part-timer to fill the space of somebody who is not there because they're out due to paid leave. You can use it to give spot bonuses to other employees that have to cover for that employee who is out on paid leave. So those are some options that you can do. The number is up to $3,000 per leave instance. So if an employee takes leave, one time, it's up to $3,000, and it's up to a total of $6,000 per employer. And so it's not infinite, this bucket of money. And so if it's something you're interested in and something that pops up, I would jump on it as soon as possible, because who knows if there's going to be any money left when you apply. Who knows if the funds are going to run out quickly? Who knows if they're going to need another bill from the legislature to fund this or not. And so if that's something that might be interesting to you, that is something that it would behoove you to move with a quickness on if it ever comes up where you have an employee on paid leave and you're a small employer and you want some help from the state to cover that paid leave. This is also all done through Deed, and it's all done online through the paid leave administrator account. Speaking of which, paid leave administration, again, Deed runs this, and it's run specifically under the Family and Medical Benefits Division, and it's going to be run, like I said, like UI, because Deed runs UI, unemployment insurance. And so the administration of both unemployment and paid leave are going to have a lot of similarities. Like unemployment, Deed is going to be making the decisions regarding paid leave eligibility and employee paid benefits. Just like when an employee applies for unemployment, you don't get to decide whether or not the employee gets unemployment or not. You can present the facts, tell Deed which way's up, and you can contest determination. But the ultimate determination is made by Deed itself. So employers are going to have accounts for paid leave. You have to register with Deed for the paid leave program, and paid leave has partnered with the unemployment division to use unemployment's online system for collecting wage details and premium payments. Why reinvent the wheel if they have it already going, right? Similar to unemployment, Deed is going to make all the decisions about eligibility and benefits. You don't get to approve or disapprove. Just like with UI, you log into your account with Deed, you see what's going on, and see if claims have been made or paid. All right, leaving the state behind us, we can talk about the different types of benefit plans. There's a state plan, which we've covered pretty much in detail, and there's a private plan. And there are some differences between the two. State plan, you have to use the paid leave account set up with Deed. You have to, do all the things by the state rules, which includes, interestingly enough, the benefit year. So the benefit year, no matter what plan you use, is going to be 52 weeks. But with the state plan, the benefit year is not fixed. It's fixed only from 12 months looking back from the date of first use, actually probably looking forward, if I think about it. But I suppose you look over the past 12 months, if you want to count back that way, to determine how many days, benefit days have been used. Compare that real quickly to the state plan or the private plan, and you don't have that same, you don't have to use the same rule in terms of look back time. So you can also use an equivalent private plan. So employers have to get an exemption from deed in order to use a private plan for paid leave. And so if that's something that you want to do, you should probably jump on that train pretty quickly so that you can get approval before the Jan 1 and the whole thing gets rolling. The rules of it are real simple in terms of what the requirements are. It has to be at least as good as what the state offers. It has to offer at least as much time off. It has to cover the same reasons for use. It has to provide equal or higher weekly payments when it is used. It has to allow for the same intermittent leave. And it can't cost employees any more than they would pay under the state plan. Now, you can always provide more benefits if you want to, but you cannot go under what the state requires. If you have an approved equivalent plan, you will not be required to pay premiums to the state. You will still have obligations under paid leave law. So equivalent plan employers will still have to submit wage detail reports to the state each quarter, and you're still going to have to comply with filing requirements, requirements to notify employees about coverage, and you're going to have to keep your records for 6 years. The benefit year, though, is different. And you can choose more like you can with FMLA for those of you that are familiar with it. You can choose either a fixed 12-month calendar year, plan. It can be another fixed 12-month period. It could be your fiscal year, say your July 1 to June 30th. That could be your 12-month period. It could be the 12-month period measured forward or backwards from the date of first use. So there's more options in terms of how you define the benefit year, which is important because I think we're going to talk about it in a little bit. Yeah, the next slide, actually. We're going to talk about leave stacking and stuff like that. And finally, on this one, the private plan can be used for both medical care and leave, or for just medical, or just for care leave. So you can have a private plan for medical leave. You could have a private plan for care leave. You could have a private plan for both. And there are some employers out there that are mixing and matching and going one way and the other. All right. Now, before I get ahead of myself, we're going to talk about paid leave and other programs. So like I mentioned, a lot of this is similar to FMLA, and that's because a lot of the leaves are real similar, the reasons that you can take leave. So FMLA, as those of you who might not know, is a federal program administered by the U.S. Department of Labor, Wage and Hour Division. It allows eligible employees to take unpaid job-protected leave for specific family and medical reasons, and it requires continuation of group health coverage. Some reasons, under FMLA that someone might use that would be real similar to the paid leave program is an employee's own serious health condition, family care, child bonding, and so on. Minnesota paid leave and FMLA may be taken concurrently, but the requirements are different. For example, FMLA is unpaid, paid leave is paid. FMLA kicks in, after 3 days of leave, potentially. Paid family leave here was 7. So the key point here is that as an employer, you can require that any leave taken under paid leave can run concurrently with the leave taken for the same purpose under FMLA. And what we're doing here is we're avoiding leave stacking. So if you don't have it in the policy that it has to be taken concurrent, and you have both FMLA covered employer and your employer in Minnesota and you have to do paid leave, theoretically, someone could stack up 12 weeks and 12 weeks and get 24 weeks, 12 unpaid, 12 paid, and have job protected leave. And so you want to make sure that your policy for paid leave requires that any leave under FMLA be taken concurrent with the paid leave. Secondly, Minnesota Pregnancy and Parenting Leave Act. So the Minnesota Pregnancy and Parenting Leave Act is also referred to sometimes as the Minnesota Parental Leave Act. This paid leave program does not replace the Minnesota Pregnancy and Parenting Leave Act. However, similar to FMLA, you can require that employees that take leave under paid leave have that leave run concurrently with any leave that is taken for the same purposes as under parenting leave or parental leave or whatever you want to call it. Again, this is going to avoid leave stacking, so they can't take their leave under the Minnesota Pregnancy and Parental Leave and then take another shot at the apple with 12 weeks of FMLA. Note, though, that any child born in 2025 may entitle their parent to bonding leave in 2026, as long as that leave is completed within 12 months of the birth or hospital discharge. So there's a little overlap on that's probably going to be probably a couple lawsuits on that to give us some clarity in terms of how they're going to manage that. Third part here, Minnesota Earned Sick and Safe Time. Paid sick leave is what I call it. So paid leave and state paid sick leave are two different programs. The Earned Sick and Safe Time program is administered by Department of Labor and Industry, not like DEED. DEED is administered again, or not paid leave, which is administered by DEED. It rhymes. Earned Sick and Safe Time began Jan 1 of 24. And there are some similar reasons for use, but the main difference here is that there's not a 7-day consecutive absence period required like there is under the Paid Leave Act. The Earned Sick and Safe Time or the Paid Sick Leave Act is, I have the flu, I caught a cold, I have a stomach bug. Those are, more short-term generally in mind. Definitely you can use paid sick leave for longer-term illnesses, but the main bailiwick of the paid sick leave laws is going to be for those shorter-term absences. Best practices with these three is our suggestion is to coordinate legally required leave years when you can. So for example, if your FMLA leave year is the calendar year, Jan 1 to December 31st, you might want to think about changing that if you're going to do the state plan, and the state plan is a 12-month look back plan in terms of the 12-month period. And what that'll do is that'll eliminate the leave stacking. It'll eliminate potentially someone being able to get 24 weeks of job protected leave built up for one single instance. Do note, however, what is today? Just October 22nd, there is a 60-day notice requirement if you're going to change your FMLA leave year. And so 60 days, my math would be probably November 1st. And so if you are interested in doing that, something you should do right quick so that you can get that 60-day period, the 60-day notice period in before the year starts and paid leave commences. Additionally, consider what benefits you could use to top off the partial wage replacement of paid leave. We talked about paid sick leave. Could an employee use their paid sick leave to top off the amount of money that they're getting from paid leave as a wage replacement? Because remember, paid leave doesn't pay 100% of the salary, it only pays a portion. So there's a difference there. Could an employee use vacation or PTO to supplement that income that they're missing to make up the difference, to make them back to their normal wages. Another option may be short-term disability or long-term disability, depending on the length of the reason for paid leave. So if you have a company-provided short-term disability plan, maybe that could add into your employee being able to make a claim in order to recover lost wages. It will be interesting to see how these plans work, though, because in reading numerous of these short-term disability plans, they do state that if you do earn any income from another source during the time you're on short-term disability, it's going to reduce the benefit amount by the amount of money that you receive. And if you receive a certain amount, you're going to get over a certain amount, you get $0 from the short-term disability plan. Not all plans are written the same, though. So check with your, if that's an issue that you think you might have or might be interested in, check with your short-term disability carrier. And they should probably already understand how their STD plan works and is going to dovetail here with the paid leave plan. All right, now notices. So there's two main notices you're going to have to provide to employees. You're going to have to provide a workplace poster, and this is going to be developed by deed, and you have to post this in a quote-unquote conspicuous place. I think the easiest place is where you put your other labor law posters. And the second thing you're going to have to provide is a written notice. So your employers are going to have to provide a written notice that has information about the availability of paid family and medical leave benefits. To the employees, and there has to be an acknowledgement. And so the employee has to acknowledge that they received the notice. There's a couple ways to do that, right? You could make them have a wet signature and say, sign this acknowledgement and send it back to me. You can have them reply to an email saying, I got it. You can use something like DocuSign or some other electronic tool that tracks delivery and receipt and acknowledgement. Additionally, deed is developing some materials regarding the workplace notice posters and written materials that you guys can use to meet the requirements from this slide. This next slide here is just going to be a copy of the poster. It's not one that I would suggest you print out this slide and hang. In a couple slides, we have the link to where you can get the posters and notices. But this is what the notice looks like. It is not the informational poster. There's a difference. This is the required notice poster, and then there's an informational poster. Make sure that you grab the right one. And you must post it in English. One other requirement is that you have to post it in another language other than English, which is the primary language of 5 or more employees or independent contractors of that workplace, if deed has actually completed or created that notice. So if you have a workforce that is fluent in another language, check with deed on the site that's coming up to see if there's a postage in a different language available that you could also hang up. They're currently working on posters. I just checked a little while ago and I didn't see any. So right now you got English. All right, then there's a sample notice. This is a sample notice. Deed also has this available. Each employer has to issue this to each employee not more than 30 days before they start work, or 30 days before they start getting premiums pulled, whichever is later. And the following information has to again be in the primary language of the employee as provided by the department. It explains a whole bunch of things, such as the availability of family and medical leave benefits, including the right to reinstatement and continuation. It talks about the amount of premium deductions. It talks about the premium amount of the employer. It talks about some things that are real simple, like name and address of the employer, ID number of the employer as signed by deed, instructions on how to file a claim, mailing address, telephone number, email address of deed, and other stuff that deed deems important to be in that notice. Similar, we talked about delivery has to be acknowledged by employees, and delivery is made when an employee provides a written or electronic acknowledgement of receipt of the information. You have to have that acknowledgement, save it, put it in the personnel file, keep it in your HCM. However you keep records, make sure you keep a copy of that acknowledgement. And should an employee say, you know what, I'm not signing it, make note and keep track of your efforts to track down those employees, copies of email and say, hey, I never got your acknowledgement back. All your efforts to try to get that in case something ever comes up. And additionally, I think there's two forms of this notice, one for small employers, one for large employers, to make sure you snag the right one. And finally, our last sample notice here is going to be the sample notice for an equivalent plan. It's similar to the previous slide, but it's still in the blank. So you put in the details of your private plan, private equivalent plan, and send it off to your employees. Same requirements apply, same distribution and acknowledgement requirements apply. Again, just to note, make sure you grab the right one, small employer versus large employer. And it's pretty straightforward. This next slide is just the site that you're going to find these deed resources on. And so the link on this page is just going to be where you go. Dan, if you could scoot up a slide. Here we are. We're not going to spend a lot of time on this page because you guys are getting a copy of the deck. You can just copy and paste it, slap it in your browser, and away you go. All right, moving on to deadlines. November 10, 2025. That's a couple weeks. That's your cutoff to request or equivalent plan substitution from the state. And so if that's something you're interested in, you should get on your horse. December 1st of this year, that's when you have to provide written notice of your paid leave, of the paid leave plan to employees. And again, delivery is considered complete when the employee acknowledges receipt of the notice. January 1 of next year, paid leave benefits become available to employees. That means they can start taking paid leave under the plan. And also the time when employers can start deducting the employee's share of the premiums from their paychecks. And then April 30 next year, we got the first quarter employer premiums due, just like your payroll taxes. You pay those quarterly, 1090s or whatever they are. And similar, with your SUTA and PUTA, you pay this quarterly paid leave tax to the state. And it's going to be based on wages from the first 3 months of the year. All right, moving on to what employers can do to prepare now. Get those notices ready for your employees. Again, they must receive them by December 1st, and receive means acknowledge. So not only do you have to get them in their hands, but they also have to send back something that says, yeah, I got it, or a signed acknowledgement, or a DocuSign or something similar through your HCM or whatever software you might be using to track whether or not these are actually delivered. Prepare for use for your prepare for leave use by your employees. So be aware that as soon as January 1st, 2026, somebody could be using leave under this new law. Make plans for your payroll deductions. Make sure your payroll software can handle it. Make sure that if you're using HCM or whatever, make sure that you know how to do the calculation, or that your software can handle the calculation and is ready to do it. Set up your account with Deed. Designated your paid leave administrator within your organization and sign up on the Deed website. It's going to be linked to your unemployment account. I would do it now and get it done with and get it out of the way in case there's any hiccups. And then look at your paid leave account with Deed for more information about payment of paid leave premiums. It's going to give you more details once you sign up. And it's supposed to be real similar to how Deed handles the UI portal. So it should look familiar to all of you in Minnesota. Last thing, update your policies. Make sure that you have a written paid leave policy. If you want it, put it in your employee handbook. I just updated our employee handbooks for next year, and I updated the Minnesota supplement, and we have a paid leave policy in there already. And so if you've done your handbook within the last week or so, you should see that with us. If not, update your handbook or get an updated policy if it's not through us, so that you are ready to go once January 1 hits. So how can we help? Ask us. We're well versed in new and existing laws. I spent, 20 hours last week updating employee handbook language to make sure that it's all ready to go for things that come in January 1st of next year. And so this is something that we're on top of. It's something we monitor, and something we're readily making changes for as it happens. Pay attention to our newsletter. If you haven't signed up for our newsletter, sign up. I think there's a link in the chat to sign up for it. Dan puts that together. He does a great job. Has a bunch of great information in there about what's happening and coming down the pipeline with employment laws, HR stuff. If you're already a subscriber, just keep an eye out for that every Tuesday. If you aren't, either click the link or shoot us a message at info@myHRcounsel.com, and we'll get you that. Again, that email is going to be on the last slide here once we go forward. So you'll get the deck. It'll be in there. You don't have to write it down. And we can also help you advise on how to handle paid leave. It's a complex law. It's new. There are no answers to 100% of everything that's going to happen. So if you have questions and you're a myHRcounsel subscriber, please reach out. We'd love to help you. All right. That wraps it up. Thank you all for joining us today. If you need help, reach out with questions. There's our contact info at the end. Those of you who are already subscribers, feel free to submit tickets with questions so we can help you with them. And Dan, do you have any last words?
Yeah, thanks, Andrew. Thanks, Michael. That was some great material today. Thank you, everyone, for attending. As Andrew said, if you have any questions on Minnesota's new paid family and medical leave law, we ask that our clients open up a ticket directly in our Ask an Attorney portal. If you are not a client and would like more information about the new law or how we can help you with any upcoming changes, please email us at info@myHRcounsel.com. As I mentioned earlier, we will follow up with an email with the recording, the slide deck, as well as the HRCI and SHRM recertification credit. And we hope to see you on another webinar in the future, and we hope that you have a great rest of your day. All right, bye now.
Thanks, everyone.